Constitutional Court. Our speakers are Igor Koliushko, the senior expert of Reanimation Package of Reforms, head of the Center for Political and Legal Reforms, Mykola Koziubra, former judge of the Constitutional Court of Ukraine, Volodymyr Shapoval, former head of the Central Election Commission, Kyrychenko, working group manager at the Reanimation Package of Reforms. You're welcome.
Добрий день.
Good afternoon. I am Igor Koliushko, that has been mentioned. I represent the Center of Political and Legal Reforms from the very beginning. After the victory in the Revolution of Dignity, after the coalition, and after the Reanimation Package of Reforms was set up, one of the focus of our attention was constitutional reform. And during this year, we have done quite a lot. Our proposals today are considered in discussions at the Constitutional Commission, which is set up officially by the President of Ukraine on decentralization, on judicial reform. And after these two most important blocks, a few months ago, we started working on the third one, how to make Constitutional Court in our country independent, professional, the body which could ensure the rule of Constitution of Ukraine, which could be efficient judge for the senior authorities. As to what we have done in relation to the 12th section of the Constitution, the others who will speak will tell you about that. Some of the people who were working on this section are the members of the official Constitutional Commission, that is Mykola Koziubra and Serhiy Holovatyi. Some were not included into that commission, even though we all applied to become members of the commission, but nevertheless we continue to work, and we believe that our expert knowledge, we as experts, as civil society activists, would believe that our task is to suggest scientifically and technically substantiated options for resolving the problems, and the politicians will decide what to include into the Constitution, what not to include. When we started our work on the Section 12 as to Constitutional Court, first of all, we considered that the Constitutional Court should be within the body of state authorities of Ukraine. We were against those adventurous proposals of some politicians in our country who were saying that the Constitutional Court discredited itself and it has to be liquidated. Maybe the court was discredited, but that was done by people, by judges who worked in that court and who were making decisions on its behalf. And as part of the reform, we need to decide on how to better form the Constitutional Court, not to discredit it again. But any other options, delegating these powers to the Supreme Court, to our mind, is worse option, because constitutional jurisdiction is specific, and the practice shows that the judges of the courts of general jurisdiction are not the best judges in constitutional jurisdiction, because this requires a different approach to the analysis and decision-making process. So how we suggest, what do we suggest as to forming the reform of the Constitutional Court, as to expanding its powers? I would like to invite Mykola Koziubra, the professor of Kyiv-Mogila University, the judge of the Constitutional Court, retired judge of the Constitutional Court, to take the floor.
Thank you. Thank you for this opportunity. I wanted to start with what Mr. Koliushko began, that in fact claims to the Constitutional Court, there are too many of them, as to the judiciary in general. And there are different positions, attitudes of politicians and of journalists to this issue, and they come down to one point, that the Constitutional Court discredited itself, and that's why we need to take out those powers they have according to the Constitution, and we should give that powers to the Supreme Court. I can tell you, this is a sign of not understanding or misunderstanding the essence of the constitutional jurisdiction, and that place of the Constitutional Court it must have in the state. And yes, according to old European tradition, that was started by Austrian lawyer, scientist, Kyrychenko. One of the arguments to create a constitutional jurisdiction as a special jurisdiction was that judges from general courts of general jurisdiction, they are not ready for such a type of activity. And by the way, because I had to participate in the development of projects of the Constitution at the beginning of our independence, yes, Western professionals paid attention to the fact that judges of general jurisdiction courts not always can be ready to such profession, such activity. According to the old tradition of European tradition, and there are some bases for that in constitutional courts of Europe, they have no judges who prevail, but professors from universities. I repeat, this is a tradition from the very beginning of formation of constitutional courts in Europe, and they still have this tradition. There are some countries and which in constitutional courts they don't have any judge at all, and they work quite well. And we had it differently. If in the first constitutional court which had to work for, and Professor Shapoval, who is present here. Not majority. Judges of the Constitutional Court were professors in public law, constitutional law, and only 1/3 were judges. Now in the Constitutional Court, judges prevail. Very often not from the highest instance, as a rule, not of the highest instance. That is, according to European standards, such situation cannot be allowed. I cannot say that is the main reason what was we had in the Constitutional Court, though that is one of the reasons why it was so unsuccessful and continues to work unsuccessfully in its combination. So that's why when we started to reform the constitutional jurisdiction, the first task was not to liquidate the institute of such jurisdiction and the Constitutional Court, but to make it in a way that it has people who are professional, known professionals from reputation, certain reputation and certain professional life experience. That's why we were looking for the ways how to do it. And it's not easy, I can tell you. And there is no proposal which is a guarantee that under our conditions they can work 100%. And there is no need for me to tell you about that, because there are different reasons for that. But at least we were trying to offer some kind of a different model of formation of the Constitutional Court than it is provided by the current Constitution, which would be more transparent and which would involve people, legal community, for example, at least. That's why one of our proposals is to take out those who participate, to take out the meeting of judges who appoint the representatives to the Constitutional Court, and there are some results for that. And this is an institute which is quite slow to collect the meeting of judges. It's very difficult to bring them together, and there were cases that there were they didn't want to send new people, and because of different reasons, there was pressure from politicians, and the Constitutional Court, the meeting of judges not always was guided by criteria of professionalism. And even among judges, they delegated to the Constitutional Court judges from the low instance, which is, according to European standards, it's not acceptable. And finally, a meeting of judges was politicized, and it was under the pressure of other branches, especially our executive branch of power. That's why I cannot tell you that the meeting of judges justified the faith we put in it. European practice is that the Constitutional Court consists of 3 branches, not in many countries. There are such cases. Again, not meetings, but high court instances or special bodies like our highest justice so not I support personally the position that the Constitutional Court must have judges from general jurisdiction, limited number. And it must be there because of the Constitutional Court. The case law is more or less related with the principle of competitiveness and certain procedures, and of course judges who come to the from general jurisdiction courts, they follow those procedures and principles of competition, and professors and I personally, my attitude is quite skeptical to that. So this for that balance in the Constitutional Court, probably it makes sense to have several judges from higher instances. They understand, not at the very beginning, but they start to understand that work. and that would allow to balance the Constitutional Court. And now the model which is offered is that the judges of the Constitutional Court are imported by the Parliament in difference to general jurisdiction practice. Not political bodies, and the Parliament is a political, but we cannot make it in a way that political organizations wouldn't understand. Even in Europe, where they have Constitutional Court, because they fail to go around politicians. So the Parliament participates in this process, but first of all, they appoint judges at the proposal of a special qualification commission, which can consist of judges who are retired, not only probably, only, but the Constitution, that's enough. Special commission which suggests those judges, and the Parliament doesn't have a special freedom of consideration. They have to vote and appoint those judges who are recommended at the proposal that's a special qualification commission. And judges are appointed, if not by 2/3, there were such proposals, at least 3/5. It requires 170 MPs. Similar models exist in Europe. What we suggest, and our experience and experience of other countries is taken into consideration. How it works? I don't know. It's very difficult to anticipate, because we live under such conditions when not formulas constitutional are decisive, but many other factors, and very often the factor of making sense. And why we suggest 3/5, because there is less opportunity for us to have the distribution into factions in the Constitutional Court. I repeat that this model is not a panacea, but in our opinion, it is. It must work better than the model which we have today. As to some other novelties in that part about the Constitutional Court, probably you will hear about the details of members of that expert working group. Thank you for your attention. Thank you, Volodymyr and Mykola. Thank you. I invite Professor Shapoval, also a judge of the Constitutional Court. He's a retired judge.
Good afternoon. If I have not greeted you, I am greeting. I would like to touch upon our work in a wider sense of this. I would like to talk about motivation, why we started doing it. Possibly the problems of Constitutional Court are such which are of importance now, because the Constitutional Commission is developing some new cases, but I believe, well, from the very beginning we agreed to work not just on this section, but to write again the section on the so-called triangle, the organization of power of Ukraine, the status of the Verkhovna Rada, of the President, of the Cabinet of Ministers, We hope that this will be perspective for us. Will it be perspective from the point of view of authorities? That's another question. And if, for example, we had a very good high quality project, then we wouldn't have the problem that took place on the 8th of December 2004 when the law on introducing amendments to Constitution was passed, which is called the law for Tuz, which weakened the status of the president, but in fact the text of the Constitution was distorted and it became problematic. That is our joint motivation. I believe my colleagues will support me in that. Myself personally, my personal motivation was this group unites people who have actively been working on the Constitution of Ukraine. These are two members of the working group, the member of the Constitutional Commission in 1995, when we were developing the current Constitution of Ukraine. It is simpler because we know the material. I would like to say that I feel comfortable with these colleagues. I do not need to explain a lot. Everything's self-understood. The professional discussions are important because you do not need any lecture or any special explanation. And another motivation, my personal motivation, I don't want to look as a provocateur. There was a mistake. It was mentioned that some were others were not included to this commission. I refused from the proposal to recommend, and I refused to become the member of the commission. The key motive was professional. I will explain, and that's motivation of my participation in this work that we have been conducting. Today, Ukraine lives in the situation when the Constitution is called the law of Ukraine on renewal of the action of some provisions of the Constitution, which was passed on the 24th of February last year. February last year was the process of catharsis. That was the period that many people characterize as revolution, post-revolutionary period, and so on. And then the law was passed that today is presented as the Constitution, but the lawyers, serious lawyers, know that that law was passed without any proper discussion in this society. Of course, we understand revolutionary situation, post-revolution syndrome, but it was passed without the discussion at the Verkhovna Rada. It was passed without taking into account the requirements of the Constitution itself as to introducing amendments to the Constitution. Maybe some will believe this is incorrect, but from the point of view of a refined legal approach, this law is as exotic as the resolution of the Constitutional Court on the constitutional reverse, when the Constitutional Court made the resolution that the Constitution, which was passed in 1996, becomes effective. That is another legal distortion. And what is not pleasant for me for a year, that passed, they have not been made any things that any measures, no measures were taken to legalize our Constitution. To me, it looks doubtfully legal. And to introduce amendments to this legally doubtful Constitution, maybe that's the way to legitimize it, to make it more look better. I understand that the society does not understand these secondary things, but once we demand the authorities and the population to live according to the law, let us try to live according to the legal constitution. That is another motive for me in the work that we, I hope, will continue jointly. As to the Constitutional Court, I would like to emphasize we have the consensus. The product that we received and the result is our joint position. We had no principal differences. People who worked, they arrived at a joint assessment, joint text. They drafted this text. I don't have anything else to add. I can say that again, I emphasize that maybe in a wider format, we will be working in the future outside the system, outside any structures created by the authorities, because believe me, I am an experienced person. From the point of view of being in power, the authorities want one thing, comfort, to have comfort, legal comfort as well. And the society wants the comfort for the society. And the interests and needs of the authorities do not always coincide with those of the society. So we will see what the result will be, but we will try to understand what are the requirements of the society and get them materialized in the text. And I hope that in the future we'll be talking about developing the new version of the Constitution. That's my personal opinion. I do not invite my colleagues to support it, but that would be correct. People who work now, I'm sure this could look not modest, because I believe I am part of them. These are people who understand perfectly well the material of the Constitution and who are able to prepare very clear constitutional text. That is all. Talking about the content of this section, if you have questions to my colleagues, to myself, will give you answers. I wish you to live in conditions of constitutional state where people will have no doubts about legality of constitutional text. There are such doubts because any serious publisher does not publish the text of the Constitution. There's no text of the Constitution. There's no legal text of the Constitution of Ukraine. Thank you.
And I invite Serhiy Holovatyi, member of our group, an MP, Minister of Justice. He was a Minister of Justice several times, an MP several times, and member of the Constitutional Commission also. Maybe I didn't mention the proposal as to how to change competence and powers of the Constitutional Court. Introduce me. That's the way they, there's as an MP, not as a minister, not as someone. Not that I'm a professor, but all my life, professional life since 1990 in the Parliament. I'm in the constitutional process. That's why I will begin from motivation. I don't feel pity that I joined the Constitutional Committee or commission of this president, and because in the previous president, here Constitutional Assembly, they did not include me, and they knew why. Why I don't feel pity, because there is a Constitutional Committee and people, and it convinces me that we have to do it. And what should be done? We should do what That's the last presenter told that we don't have a legal text, and I have the only one, which was approved on June 28, 1996. That's a legal text of the Constitution. What in 2004 illegitimately was done, that is an illegitimate text. That the Constitutional Court made a decision as if return, though there is no such a decision, and the return happened de facto at the request of Lithuanian Speaker of the Parliament and the head of the Secretariat of the Parliament, Zaychuk, who put on the same day on the official website a different text without legal basis, and they should be criminally responsible for that, and that is not a legal text. The text, the Parliament, as if returned, and then the Parliament returned. That law is also legitimate. So whether we want or not, we have a legitimate text from June 28, 1996, and now we're facing the situation where we have to correct that text partially, in parts. To correct it, we have to correct it not because it's not perfect completely, but because, as the Ukrainian experience shows, those paragraphs that were written at that time, they didn't work. And now when we write, even the paragraph on the Constitutional Court or judicial branch, we have to consider that this order that was done to the Constitution by all the presidents, all parliaments of that period, all other institutions, they did something different. They distorted the Constitution by laws. Look at the laws of Kivalov through the whole judiciary. They created specialized courts. I will not go into details, but Ukrainian practice proved that in the new text, we should put safeguards from Ukrainian stupidity of Ukrainian politicians, of stupidity of Ukrainian judges, of criminal violent actions, including this day of the Constitutional Court of Ukraine. They translate me. There is one example which proves that this Constitutional Court of Ukraine and its chair, they abuse. They know that there will be no responsibility for them. So working on this plot, we were trying to find those possible safeguards that for Ukrainian society, for Ukrainian mentality, Ukrainian political class, Ukrainian public servants, Ukrainian top official will minimize their wildness, that Africanship, as Asianship, stupidity, their own stupidity and irresponsibility. That's the first point. Second, I disagree with my colleagues that the Constitutional Court discredited itself. Where do I disagree? I disagree that the Institute of Power discredited itself. In 20 years of this Constitution, or 19, we don't have any Institute of Power that discredited itself. Or did not discredit itself. We don't have any president in Koliushko, Kuchma, Yanukovych, Poroshenko. We don't have any parliament and concrete deputies. We don't have any government in as a ministry. No court, no counting chamber, no human rights ombudsman. The scapegoat for traditional Institute of Power should not be a scapegoat. They were discredited by people So it doesn't work in Ukraine. In European countries it works. In Ukraine it doesn't work. Why? Is the Institute of Power bad? No. But people who are there and who move it, who make it active, they bring to these consequences. Why don't I feel pity that I joined the group? Because in the Constitutional Commission there are a lot of neophytes, like new faces it is called now, so young generation, which says we should liquidate the Constitutional Court. It discredited itself. We should liquidate the administrative courts. They have discredited themselves. They prohibited during the rules of dignity. They prohibited demonstrations, etc. We have to liquidate them. And by the way, these are quite known people. They are respected people. Then I told them, liquidate the cabinet of ministers and the parliament. Do they have so moral respect, so high moral respect? When for 2 days there is a fire. But there is no minister on emergency for how many months? For 2 days there is a fire and nobody informs people about the situation, what they can eat and drink in that area, dose, radiation, pollution, what should be done, what should be the case. Nobody informs them. April 26, 1996, Chernobyl, Vice Prime Minister, who, at the request of the Prime Minister, Minister of Culture, it's a joke. Do we need such a cabinet of ministers, which for 2 days we have such an awful accident in half a century? It's not the issue of the institute, but it's the matter of people and concrete persons. So in the Constitutional Commission, it's very difficult to fight against these neophytes who have a reaction to the Institute of Power, amoeba. So that's the simplest reaction. I see and react. Bad. If it's not from me, it does supported me, so we liquidate it. What goes after?
So the Constitutional Court in principle is a phenomenon which appeared after the Second World War to two countries, the Czech Republic and Austria, had it before the Second World War, but then all the European countries introduced it. And we say, let's liquidate it, and that's why we are working and we're trying to prove it, and we expand it. We made this section in detail to confirm the constitutional jurisdiction, because it's called the court, but it's not the system of judicial authorities. In Poland, they have tribunal. They don't have judges. They have the members of the tribunal. These are not judges. In France also, that is a council. That is just a conditional name. But we are, after long discussion in a big working group on the judicial system, we agreed that we cannot liquidate it, and we cannot take it into the judicial system. That is a special type of jurisdiction, because constitutional jurisdiction is above the state, is above the president, above the Verkhovna Rada, above the government, and even above the judicial branch. The Constitutional Court does not cancel the resolutions of the court, but interprets them, and the interpretation is mandatory for the court. And all these people who do not understand things decided to conduct revolution even here. So that is why we are for this institution, and we see how in the Ukrainian environment we can not just save it as the classical institution in Europe, but how to form it in the future. And we have to review the process of forming this core. Who discredited itself? These are the judges They were providing not the specialists on constitutional law there, and the judges cannot be there because they are not the experts in constitutional law. But constitutional law is theory, philosophy, it's theoretical work for understanding, interpreting, and creating the official doctrine of constitutional law. The judges of the first instance from Donetsk region who came after Yanukovych, who discredited the court itself, or those who were forming the court. And who was forming the court? The presidents, the members of parliament, and the judges at the Congress of Judges. That is why this institution was discredited. They sent not experts there, but some puppets who were satisfying their practical needs. And if till the revolution of dignity they had only two experts on constitutional law there, Judge Shishkin and Judge Stitsuk, and the rest were not the experts on constitutional law. That is why we believe, and we also, according to the European sample, we write who can take the position at this constitutional court. But we need to create the special commission so that they are not elected by the president, by the members of parliament, by judges. We introduce into the constitution the notion special qualification commission of judges, which has to select the candidates out of highly professional experts in the sphere of law, highly moral, and people with who are respected, and from a big list, like it's now done in our personnel policy. Then the special qualification commission will submit this list, and the commission should include the former judges from constitutional court with high morals, not those who came from Donetsk, but the experts in constitutional law. Then they will select, and out of that list, the political body will confirm the members. The second preventer, if this option works, the judge can be appointed from that list submitted by the special qualification commission, not by the simple majority. The simple majority is dictatorship of the laws. Any simple majority easily achieves political objectives. So we, based on the decision of Venice Commission, we believe there should be some compromise between the majority and the opposition. This should be 3/5, 270 votes. We cancel also the function or authority to interpret laws. The law shouldn't be interpreted by the Constitutional Court, because the Constitutional Court ensures the rule of Constitution. Its main task is to ensure constitutional order, which is based on the foundation of constitutional system defined in the first section. So the laws shouldn't be interpreted by Verkhovna Rada or Constitutional Court. The law which is applied in the judicial system and its application is to be interpreted for a specific case by this court in the system of general jurisdiction. Also, another innovation is the Institute of Individual Complaint. We didn't have that, but this should be there. That means that this is an expanded practice in European countries, which will make easier the national system, because we see that Ukraine today is almost a champion talking about the number of complaints to the European Court, because the proper general judicial system doesn't function, and they channel there many things, and Ukraine is among Ukraine, Turkey, and Russia, three countries which overburden European court. So on the one hand, we give the opportunity for a person, a physical person or legal entity, they can apply to the Constitutional Court with their case, and the Constitutional Court will consider this case, this complaint, in accordance with its function. One more innovation, which is small, but it's based on our ideology of reforming the judicial system, and that is that Constitutional Court has to form its own budget and has to defend it in the parliament. This shouldn't be done by the government, just like it is about the judicial authorities. It's not the Minister of Finance or the Prime Minister that have to form the budget for the judiciary. The judiciary are independent, they have to do it for themselves and have to defend it in the parliament. There should be the representative of the general jurisdiction defending their budget, and the Constitutional Court representative their budget. I believe that's a simple, small issue referendum. May we request you to finish? Basically, that's wrapping up. Basically, will this be perceived by the Constitutional Commission? As we have seen that many of our provisions from what we have developed by this group in the system, in the judicial system, is not accepted. Not theoretically, not ideologically, but practically, because it was wrong to form the Constitutional Commission with the participation of the judges who are holding office. It is that the judges cannot reform themselves. The judges do not want to reform, they want to leave it as it is. Everyone has its own interest, individual, corporate, and some other. So we are not convinced to how this will be accepted. We're not sure how it will be accepted, but I'm sure that this work wasn't waste of time, because even, some things are moving ahead because we do not step aside from our principal position. Thank you.
I invite all the speakers to the stage, and we have a couple of questions. Honest Statiuk, Ukraine Crisis Media Center, will speak about the Constitutional Court, and I'm interested in such a thing as a special qualification commission, which must consist of judges with a perfect reputation. And speaking about such an unengaged, not engaged, how to get rid of the political context, how will decide on that reputation, who will elect these people? Don't you think that maybe we should introduce some kind of a civic council for people to be involved? And the second question, a broader one. It's a rhetorical question, because we have the Constitutional Commission within this government. There was a Constitutional Assembly. Is it not running in the circle? And every time they introduce something new, everybody speaks about the new constitution. Will it be such no endless process? Serhiy. Who will be the first? I will discuss that now, but I would agree that the first of all, they should judge as in that court people who, by fact, it should be those who people trust themselves the most. They should work, and that is the head of the state. So he's responsible for everything which is happening in the country. It doesn't matter what kind of powers he has. So we put here that in transitional regulations that the first of special qualification commission, which should consist of exclusively of former judges or judges of the Constitutional Court of Ukraine in resignation, and but with the highest professional and moral authority. And we know who they are. We had enough of years for us to see who passed on which decisions and how they approve those decisions and opinions, and there are some criteria and materials on which can help to give assessment of a professional level and morality of judges. It could be not necessarily 15 people, but it could be 5. If we have such people, maybe in a demoralized by Soviet power society in general, and until now demoralized situation of Ukrainian politicians and public servants. Maybe they don't understand. It's very difficult to grasp and to introduce in the post-Soviet society high moral qualities and high morality. But we know that after some people leading people in Ukrainian society, people have respect to them. If we want to, that can be done also according to that appointment that should be highly professional and moral. As to the second question, briefly, everybody has something to add. I will remind you that despite that problem, that every new president spoke about the constitutional reform, but nevertheless, since 2007, the first parliamentary elections, when all political parties during the campaign, they spoke about the necessity to amend the constitution, so that model, which started to work the first time with changes, amendments in 2004, started to work in 2006. It became clear to everyone one cannot live for long according to it. It should be reformed. Then they added some other problems, the problem of decentralization and the problem of the court reform, judicial reform. Now we have the situation when there is a very high level of conviction in the society that the constitution reform is needed. It's in the manifesto of the Council of Maidan. They mentioned it on December 25, 2013. Then it was mentioned again after the victory of the Revolution of Dignity in one of the first steps in the Parliament on March 3. Set up a temporal special commission to prepare the draft law on amendments to the Constitution, and it's natural that it was of MPs and they were not able to agree on the draft. That's why, it's in our opinion, there's a high level of needs or amendments to the Constitution, but politicians will make that decision. It's important that they are guided by the interests of the society and values of Constitution, not all by their own interest before elections or before something else. I can add that the permanent constitutional process is not over after it was approved in 1996. It started and it's not over yet. To speak about me, I'm not sure that it will be over even with this Constitutional Commission and with this Parliament, because through the Parliament, the Constitution should go through the Parliament. That must go. Reasons are different. That Constitution is good, that is complied with. If the Constitution of 1996 was complied with, and if there were less different tricks to it in different years, including 2014, if there were less manipulations in 2004 and up to 2014, we wouldn't have this need. But we need changes and we need amendments. Nobody doubts that. To legitimize the Constitution, we need that. But I want that after these amendments, may them end successfully. I would like for 20 years, I want us to live without changes or amendments. We should focus our amendments on complying towards. If there is a need in change in amendments, something is not perfect. It's logic. Of course, we can say that every president, as a phrase, wants to have his own composition. I don't think so. Exactly so. 1996, we passed the constitution. Then there was a moment, despite the fact that political was not perfect, but it was clean legally. But it focused power in the hands of a president, and the society was that the president was the father, leader of the state, and that's the way it happened. On the horizon, there was a new candidate, a president, and they decided to make him weak. We remember that. And then there was a bad situation in 2004. They passed the law on amendments. And those the law is in force until now. And when lawyers were reading that, conscious, and the hair ends, if they had hair. And in Venice Commission Director, despite this and this and this, they told you broke into pieces the executive branch. It consists of two pieces. One piece is run by the president, and like today, and the other one is run by the prime minister. Some ministers are appointed by the president, and by the way, at present we have 6 orders how to replace leading positions in the system of executive branch. If you take any other country, the maximum they have 2 ways. Prime ministers and other members of the parliament, and maybe one more. So we destabilized the executive branch, which is the core of state mechanism, not the parliament, but the executive branch. And then there was a reaction. And a key point, we said the constitution is a social treaty, an agreement. Okay, how you can bring the amendments to the constitution to the parliament? Who nobody saw that. And when we asked who prepared the draft that the president brought to the parliament, there was a draft law that everybody forgets, so nobody knows who. How come? Lawyers are different, and there are good or doubtful, but the society must know. So that's the way. Prepare the draft, explain details, give time to understand, and let them pass, and let the constitution work. And our neighbors in 1987 in Poland, they did very simply. They passed the constitution by the meeting, they brought it to the referendum, and in the constitution they provided that it comes into force in 3 months after it is approved at the referendum. And for 3 months, everybody was explained what and how and where to. That's the way to initiate a social agreement, and maybe some other ways. And in principle, everything is done in Ukraine for a concrete person. And I have suspicion efforts of the Constitutional Commission, and I trust it, and I trust also NEFITs and Volodymyr mentioned. I don't know who is NEFIT, and everybody seems like with professional beards, and I respect all. I want to say that as one actor told, I don't trust, and everything seems like it will be done for a concrete political interest, maybe not personalized, but a group. But again, people will be silent, you remember. We want to take one more question.
Питання це буде останнє.
Very brief one. This will be the last one for this briefing. It's to the words on Polish experience. There's such an opinion, I heard it from the experts, that some suggest that Ukraine is refounded. Like in 1991, this independence was thrown on our heads as a snow. And we are the basically the successes of the USSR, but of also UNR. Maybe we need to organize the statutory meeting and elect the delegates, but the delegates will be the same as in the Constitutional Committee. All those who are in the Kiev City Council or in Kiev City Council or I don't know where, in Avdiivka City Council, this will be the same. And I am absolutely against it. To refounding the state is like again giving birth to same children. Are we not real people, real nation? The politicians are not real. And when we say that we have divided the executive branch into two pieces, who we? The authors of this "we" is the Kremlin. The specific names: Moroz, Simonenko, Medvedchuk. That is there, 2222. Medvedchuk took it from the Kremlin table because Yushchenko came to power and Litvin was ensuring the procedure. The court mentioned that in their resolution. There was no discussion. That was just the Kremlin project. Just like the first Kremlin project, when the Constitutional Court of Ukraine confirmed its reputation, when they cancelled two questions of Kuchma referendum. That was the first Kremlin project because the constitution we have today protects Ukraine as the state. We don't need to take from the Donetsk or from elsewhere. We do have it. It's of high quality. It's very good, but the paper is not to be blamed. The paper is not guilty of who's stepping on it. And the Ukrainian experience for 20 years of practical testing of that paper, which was dated 28th of June 1996, has proven that the paper is not guilty. The politicians are guilty who were distorting it by their practice. Now we just need to improve, to reform in order to take into account all the things that I've mentioned. What politicians did to minimize the possibility for them to manipulate, to abuse the power. And these sections, especially the section on judicial power, on constitutional power, they require these preventive mechanisms. Decentralization is like an oxygen for Ukrainian society because until today the territorial structure is a Soviet-type system, administrative centralized model. We don't have a real self-governance. Every community is without property, without anything. They still serves. The state throws them a bone as to the dog. And again, if we don't have that, the Polish experience, then if we do not have decentralization, if we step away from this centralized state where the Tsar, whether the Tsar or the government wants to control everything, well, there are too many issues. We don't need to re-establish anything, to refound anything. We have an experience, and based on that, we need to move forward. Just one sentence each. I believe that talking about refounding, we are thinking alike. Talking about some of the arguments of Serhiy Petrovich, we have our own system of arguments. It's difficult to find the complete consensus, but when we sit together, when we talk about law, the practice shows that we very often come to the consensus, and that means that our discussion is an expert-type discussion. I would like to thank everyone. Microphone. Okay, without the microphone, then after the briefing.
Скажімо, існує, у них є такі...
Дивіться, ми вас не чуємо,
так.
бо ви говорите на мікрофон. Давайте вже після брифінгу. Добре, це буде ексклюзивний жарт.
Добре, я остання
And one more. We thank you for attention and thank two organizations who were supporting us in our activity, International Foundation of Election Systems and Renaissance Foundation, that we continue to work on the program. Thank you. Thank you.
Завершується. Всі питання ви можете поставити.